Good morning and welcome to what we think will be the last meeting of the House Criminal Justice Committee for Wednesday, April the 13th. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Halsey, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio.
Here.
Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, before we get started, we do have a very full agenda today, but any personal orders before we get started? Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. My sheriff, the Honorable Kyle Hilton, is here with us, sitting right back there. When I wanted to get into law enforcement, I went to him and said, "How do I do it?" And he told me the way to do it, and he hired me when I needed a job and put me in the jail and corrections, and then later on brought me out on the road as a deputy. And so I'm very thankful for him and appreciate the service that he provides our county each day. A lot of great men and women that work at our sheriff's department. I'm proud to be a resident of Giles County.
Here. And Chairman, I just want to clarify, did you say that he put you in jail? Yeah.
He did. I had 2 hots and a cot while I was there.
Very good, very good. And I believe it is Sheriff's Day on the Hill, and we've got a full house. And I would embarrass myself if I tried to introduce all of you. But would you mind standing, please, just so we can all see who you are? I know that we've got a big crowd here. Thank you very much. And we thank you all for your service, not only for being here, but thank you for your service. We know it's an election year, and we know that it's also a work day. You've got plenty of work you could be doing today, so thank you for coming up here and watching us as we deliberate. Chairman Howe, I have you next on my list, sir.
Thank you, Mr. Chairman. I would like to recognize my county sheriff in Bradley County, Sheriff Steve Lawson. He's not only an excellent sheriff, he's also a good friend. Glad to have him with us. Thank you.
All right. And Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. And if I may, with all due respect to the rest of you gentlemen, if I can have the finest sheriff in the great state of Tennessee stand up. Sheriff Sonny Weatherford and his staff are here from Sumner County. Thank you, sir. Thank you, Chairman.
Yes, sir. Thank you. Representative Griffey.
Thank you, Mr. Chairman. Unfortunately, my sheriffs couldn't be here, but the sheriff of my neighboring county is Andy Dixon. Where are you? Stand up, please. Thank you for being here.
All right, members, seeing no further personal orders, as I said, we do have a very full agenda today. The first item is going to be, and I want to make sure that, yes, there is Chair Lady Moody right there. First item is House Resolution 174 by Speaker Sexton being carried by Chair Lady Moody. Chair Lady Moody, you're recognized. You have a motion and a second.
Thank you. If you'll give me 1 second.
Not a problem. And while you're preparing, I will say just a brief note, and you may be mentioning this as well, Chair Lady, but on this appointment, Michael Donovan of the TBI, of course, I think is a very solid candidate here. I do want to mention he unfortunately is not able to be here today. He would have been here if we were meeting at our normal committee time, had scheduled to do that. Unfortunately, he is involved in a training in another part of the state at this time. And so that's part of having high quality candidates is that they're busy. So we're glad to know that he's out serving the interests of the state. And hopefully, Chair Lady Moody, I have filibustered long enough for you to get prepared. So you're recognized.
Well, it is an honor for me to carry this. I have known Michael Donovan for a long time. We are from the same county, Tifton County. He has served us well as a DA in our the Western Division service he had, and now where he is in the comptroller's office. And I can't give enough accolades to what a great job he will do. He is serious. He is thorough. He's. I don't want to give him the big head too much, but anyway, he will do a great job. I have every confidence in his abilities and his determination and what he can do in this area. And so with that, I wholeheartedly ask and pray that this will come about, and I'm honored to carry this in his absence and for you all today.
Members, you've heard Chair Lady Moody's explanation of House Resolution 174. If there's no questions, we're ready to vote. All those in favor of sending House Resolution 174 to Calendar and Rules, please signify by saying aye. Those opposed? Ma'am, you head to Calendar and Rules. Members, that brings us to a special portion of our hearing today, which will be a nomination hearing on two nominees. First of all, we have Tom Greenholtz, criminal court judge of the 6th District, which is in Knox County, Division II, and he's been in that position since 2015. And then we will also hear from Kyle Hickson, who's a criminal court judge in the 11th Judicial District, which is Hamilton County, Division II, and he's been in that position since 2020. And as I typically like to do before we enter into this, as folks who are watching, whether live stream or in the room, so that they'll understand this process. A lot of folks don't realize there's a lot of attention paid to judicial confirmation hearings at the federal level. A lot of folks don't realize back home that we also have this obligation at the state level. So I want to briefly explain why we're here today. A constitutional amendment proposing the judicial nomination confirmation process was approved by the voters of the state on November the 4th, 2014. The procedures governing the process were passed into law by the General Assembly on January 28, 2016, and when a vacancy occurs, the governor appoints a nominee to fill the vacancy subject to a vote of both chambers of the General Assembly. The role of the Criminal Justice Committee of the House of Representatives and the Judiciary Committee of the Senate are to hold hearings on the nominee and to provide a recommendation either for confirmation of the nominee or rejection of the nominee to their respective bodies. And then I'll kind of talk about how this hearing will proceed. So we're going to hear from the governor's chief counsel, as we have many times now in this committee. We'll introduce each of the nominees. Each nominee will have an opportunity to make an opening statement, and then I'm going to open up the floor for unlimited questions and answers from the committee. And then following those questions, we'll go back into session, and I will entertain a motion either for confirmation or rejection of each nominee individually. So if there's any questions about that process, I'd be happy to answer. And if not, we will now go out of session. We're now out of session, and I would like to call forward Jonathan Skrmetti, the governor's chief legal counsel. Sir, you're well known to this committee, but if you could please introduce yourself for the record and share with this committee whatever you'd like.
Thank you, Mr. Chairman. Jonathan Skrmetti, chief counsel to Governor Lee. It is a privilege to appear before you today to introduce these two nominees. Both of them are distinguished members of the criminal court bench, having served as criminal judges already. Both of them, prior to their appointment to the bench, had distinguished careers in practice. Both are proud graduates of the University of Tennessee School of Law. One's a proud graduate of UTK as an undergrad. The other is a proud graduate of UTC as an undergrad. I will not take too much time with them because I know you're busy, but I will say we are very enthusiastic from the governor on down through the administration about the opportunity to add these two gentlemen to the Court of Criminal Appeals. I would also remind you that pursuant to Rule 210 of the Code of Judicial Ethics, they cannot comment on cases that either will be or might be before the court. So if you ask a question that they can't answer, I'd just like to remind you that's not because they're trying to be evasive, it's because they're trying to comport with their ethical obligations. But we very much appreciate your time squeezing this in at the end of session, and it's my privilege to introduce Tom Greenholtz and Kyle Hickson.
Judge Greenholtz, we will start with you. If you could, again, state your name for the record and make your opening statement.
Mr. Chairman, thank you very much for having me.
I'm sorry, if you could make sure your microphone is turned on. The red light should be illuminated.
Red light is on. Mr.
Yes,
Chairman,
sir.
thank you very much for having me here today. It's a real pleasure and a privilege to appear before this committee. My name is Tom Greenholtz. As the chairman announced, I am currently the criminal court judge in Chattanooga in the 2nd Division of the Criminal Court. In 2015, Governor Haslam appointed me to that position and was reelected thereafter. It's a real privilege to be here today. I'd like to extend my thanks first to this committee for opening up your doors, allowing me to come in and to meet you all. I'd very much like to thank Governor Bill Lee for expressing his confidence in me, in meeting with me, and just allowing me to be part of this process. I'd like to thank my family, my wife Kathy, my daughter Caroline, and my son Michael. Without their support, no one gets this far at all. I'd also like to thank the two judges on the Court of Criminal Appeals who are retiring, both Judge Ogle and Judge Thomas. Both of those judges have given outstanding service to this state. As I heard one of our other judicial candidates earlier say, no one can step into their shoes. All we can do is hope to succeed them and do the outstanding work that they've done. Just a little bit about me. I'm a proud husband of 23 years. As I said, I'm a father of two. I'm a member of St. Peter's Episcopal Church in Chattanooga, where I serve on the vestry. I'm a proud graduate of the University of Tennessee at Chattanooga, go Mocs, and then graduated from law school in 1999 from the University of Tennessee. Shortly thereafter, I spent 3 years clerking with the Tennessee Supreme Court with then Justice Mickey Barker, later Chief Justice Mickey Barker, and then went on into the practice of law afterwards. And then, as I said, was appointed by Governor Bill Haslam in 2015. I would look forward to your questions here today. Mr. Chairman, thank you very much. It's a real privilege to appear before you all today.
Thank you, Judge Greenholz, for that statement. And we will, before we head to the next, I'll see if we have any questions from the committee. Any questions, members? Okay, seeing none. Judge Hickson, we'll go to you.
Thank you, Mr. Chairman, and also let me thank the members of this committee. As you mentioned, Mr. Chairman, this is a very important constitutional duty that the members of this committee have, and I know you take it seriously, and I thank you for that. I am honored to be here today. I do want to introduce you to a couple people without their love and help over the years, I wouldn't be here. Right behind me here are my parents, Junior and Sharon Hickson. I was born and raised in Crossville. Mom and Dad still live there. And they were very pleased and honored to be here today to support me. I want to thank them so much for being here. My wife, Rachel, is back in Knoxville with our two older girls. We decided to keep them in school these couple of days that I'll be in Nashville. But without her love and support throughout this process, throughout my career as a practicing attorney, and also since I've been on the bench as a judge, I would not be here without her love and help, and I want to thank her. She is watching today. So we have three beautiful daughters, Harper, Hattie, and Henley, and we're just so pleased and honored to be here. I also want to extend my gratitude to Governor Lee for the faith that he has shown in both Judge Greenholz and myself. I'm also thankful to Governor Lee for putting me on the criminal court bench 2 years ago when I was first appointed to serve in Knoxville. I have been very fortunate in my career that I've been able to work at every level of the state criminal justice system. I've been a trial court prosecutor. I was privileged to work for the State Attorney General's office doing appellate work, mostly before the Court of Criminal Appeals. I did that for a 2-year period. And then I spent 5 years back in Knoxville serving as Deputy District Attorney to our elected DA in Knox County, Sharm Allen. And of course, as I've said, I've been on the criminal court bench there in Knoxville for 2 years. So I'm honored to be here, honored to be a part of this very important process, and I look forward to answering any questions that you all may have, Mr. Chairman.
Thank you, Judge, for being here. We appreciate your remarks. And first, I have Chairman Holsey. You recognized?
Thank you, Mr. Chairman, and thank you, gentlemen, for being here, and I appreciate your constitutional integrity, and
Thank you.
Folks never doubt that. This is just a simple question. Most court dockets across this state are in the pages and pages, and the backlog to get to trial and go to trial is incredible. Jails are full in my own county. After your time on the bench in the criminal side, tell me how we can fix this. How do we speed this process up and be able to get people into court and through a trial process in a reasonable amount of time?
Judge Greenholz or Judge Hickson, either one?
Sure, I'll take it. Mr. Chairman, thank you very much for the question. It's important. And I think as Judge Hickson, I think would echo this. It starts with your trial court judge. Your trial court judge has to keep an active eye on the dockets. The trial court judge has a responsibility to move those cases. And so if you got cases that are on the docket year after year after year, I'm not going to say it's the fault of the trial court judge, but I will say the trial court judge bears a lot of that responsibility. I think throughout the COVID period, I'll tell you, my trials have backed up. For a while, we were unable to physically hold jury trials in our courtroom. Since we've opened up jury trials going, and Judge, my guess is the same as in your court, we're holding jury trials all the time now to clear that backlog, but we're doing it purposefully, we're doing it intentionally, and we're keeping an active eye on those dockets. So I think at first it starts with the trial court judges. It continues with the other people in the process, but that's exactly right. And I hope I've answered your question, but I'm happy to provide any further information.
Chairman Halsey, any follow-up? Okay. Any further questions, members? Representative Griffey, you're recognized.
Thank you, Mr. Chairman. Gentlemen, I don't have any questions for you or your honors. I just want to express my appreciation for both of you all, the service you've already provided to the citizens in Tennessee and upholding the law and abiding by the law and doing your duty, and then being willing to serve again in the Court of Appeals. Is a very important position, and you all both know that, and we want to just express our thanks for that and express my thanks. Thank you so much.
Representative, thank you very much.
Thank you very much, sir.
Thank you, Representative Griffey. Next on my list, I have Chairman Howell. You recognized.
Thank you, Mr. Chairman, and I just want to thank you both for the courtesy visit that you paid to my office yesterday. I really enjoyed visiting with you both and was pleased to learn that we have some mutual friends in the judicial circles. And I look at your experience and your background, and I think the governor's made some excellent choices in your behalf, and I look forward to supporting your confirmation. Thank you.
Mr.
Thank
Chairman,
you.
thank you.
Thank you, Chairman.
Thank you very
Howell.
much, Mr. Chairman.
I'll just kind of close out by saying this. Thank you both for your willingness to serve, and I'm always so heartened by the patriots that we find in state government. And again, in the political sphere, sometimes it's easy to throw rocks. It's easy to get caught up in the kind of the public persona of what's happening down here. And what I try to remind my folks back home is, look, there are a lot of people you never hear of in state government who are working hard every day to make sure that you live in the best state in the union. And I count both you gentlemen among that. So thank you for your service to the state, especially you, Judge. I know, I think our children are roughly near the same in age. I've got some young children, and I know I spend a lot of hours in this building when I could be at home at a soccer game or ballet recital or something like that. And so it doesn't go unnoticed, but I'm sure the time away from both of your families is difficult, but thank you for doing that.
Thank you, Mr. Chairman. Thank you.
Absolutely.
very much.
If there's no further questions, then we will go back into session. We're back in session, and now I'll recognize Leader Lamberth.
Thank you, Mr. Chairman. I would make a motion to recommend confirmation of Judge Tom Greenholz.
Members, you've heard a proper motion and proper second on Judge Tom Greenholz. Any discussion? Seeing none, we're ready to vote. All those in favor signify by saying aye.
Aye.
Those opposed? You confirm. Thank you,
Mr.
sir.
Chairman. Thank you.
And Leader Lamberth, you're recognized again.
Thank you, Mr. Chairman. I would make a motion to recommend confirmation of Judge Kyle Hickson.
Members, you've heard the motion properly seconded. Any discussion? Seeing none, we're ready to vote. All those in favor of confirmation, please signify by saying aye.
Aye.
Those opposed? Sir, you're confirmed. Thank you very much. Appreciate both of you being here today.
Mr. Chairman, thank you.
Thank you all very much.
Good luck as you continue to travel through this process, and this committee, again, wholeheartedly recommends both of you. So thank you very much.
Mr. Chairman, thank you.
Thank you all.
Members, I'll give us just a moment for the room to clear. I know there's some folks exchanging goodbyes. All right, that brings us to item number 2, which is House Bill 2860 by our good friend Chairman Kumar. Chairman Kumar, you're recognized. Sir, you have a motion and a second. I also see an amendment which is coded 15489. Is that the amendment you wish to move today, sir? We have a motion on the amendment. Do I hear a second? We have a second. Sir, you have a motion and a second on the amendment. I believe the amendment makes the bill, so we'll go ahead and vote to get that on. All those in favor of attaching amendment coded 15489 to House Bill 2860, please signify by saying aye. Aye. Those opposed, you adopt. Sir, we're on your bill as amended. Please describe your bill.
Thank you, Mr. Chairman and committee. Under present law, it is a Class A misdemeanor if a dog is left restrained with a cord, tether, or chain under unfavorable circumstances and suffers physical injury. But we also know that there does not have to be apparent physical injury, and the animal can still suffer. The amended House Bill 2860 makes it that if a dog is kept restrained with a cord, chain, or tether, and under difficult circumstances, such as when there is a declared national weather emergency, natural or man-made disaster, or evacuation in progress, the first offense under this bill will be a warning citation, and the second offense will be a Class C misdemeanor. Certainly, all of us care for the pets and the animals we adopt, and this just says that if the weather and conditions are bad, please let the poor thing off the leash. Thank you.
Members, you've heard the explanation of the bill as amended. I do have Chairman Halsey on my list, sir. You're recognized.
Thank you, Mr. Chairman. I had an oral amendment that I wanted to put on this bill that says there is no criminal charge if the owner can prove that the dog has had a COVID-19 vaccination. So, but I'll withdraw that amendment.
Very good. Thank you, Chairman Halsey. Dr. Kumar, you're recognized if you wish to
Well,
respond
I was
to that.
concerned for a while.
Yeah,
I
okay,
was
very
worried.
good. Very good.
Thank you, Mr.
Very
Chairman.
good, thank you. Next on my list, I have Chairman Doggett. You recognized?
Thank you, Mr. Chairman. Would this be applicable where I live in Giles County when we have a tornado warning that's issued for the entire county? They don't issue it for subdivisions or for streets or anything of that nature. It's for the entire county. Recently, we've had a string of storms that have come through, and just one portion of the county would have really applied to where the storm was, but the entire county was involved in this warning. Would that come into factor when in this language, or would it just be for if they were to narrow it down to certain streets or subdivisions?
Chairman Kumar, you recognized.
Thank you. Are you saying that the county, if the county was to narrow it down to certain streets, they're warning? Or is it that the whole county, if there is a tornado sighted, then the whole county gets a warning?
Chairman Doggett.
Well, the way this language is in the amendment, it says severe flooding or tornado warning issued by the National Weather Service in effect for geographic area. The National Weather Service doesn't issue warnings for specific subdivisions or streets, but they will for a county. And so if there's just one section, I live in quite a large county land-wise, and if one section of that county receives a tornado warning, perhaps the remaining parts of the county, it may be, just light rain. It's not a severe storm there, but they issue it for the entire county. And so my question was, how would it apply to persons who maybe lived in the southern end of the county, where it may be just light rain and their dog is tethered, versus someone on the north end of the county where there's a potential tornado? The warning has been issued. There may not be a sighting, but conditions are favorable for a tornado.
Dr. Kumar, you recognized.
Thank you. I see your point, and certainly the path and direction and timing of tornado can be very unpredictable. I think it'll be wise to take the animal off the leash.
Chairman Doggett.
Well, my question would be if someone is at work and their dog is tethered or tied, or went to the store and then the tornado warning occurs, but in reality it's on the northeastern part of the county, whereas the southwestern part where your dog is. I'm just trying to understand how that would work, because it could be confusing for the residents who are the dog owners. It could also be confusing for law enforcement and others as to what do we do in this situation, because the language specifically states, a tornado warning, or even a severe, maybe if it's a flood warning and you live on top of a big hill where you're not going to experience any flooding. That's no further questions. Thank you.
Thank you, Chairman Doggett. Any further questions for the sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 2860 as amended to calendar and rules, please signify by saying aye. Those opposed? Sir, the ayes have it. You had to calendar and rules. If you wish to be recorded as a no, please let the clerk know.
Thank you, Mr. Chairman and committee.
Thank you, sir. That brings us to item number 3, which is House Bill 666. I want to make an announcement that this bill was not calendared in Senate Judiciary, so there's been no movement on this bill. But I also want to point out that a subsequent bill encompasses this language. So we have a bill coming up later on our cannabis calendar by Representative Jernigan, which should that bill make it out of this committee, this language is included in that, and that bill has passed the Senate. So without objection, that is going to the special calendar. That takes us to item number 4, which is House Bill 630 by Representative Gillespie. Sir, you have a motion and a second, and I see 2 separate amendments filed.
Thank you, Mr. Chairman. Yes, 2 different amendments. Which one do you? They're both on the bill. They should be.
I'm being advised we need to adopt both amendments. So first, we have amendment coded 5736. Sir, you have a motion and a second. All those in favor of adopting amendment coded 5736, please signify by saying aye. Those opposed, you adopt. That brings us to House Criminal Justice Subcommittee Amendment number 2, which is amendment coded 16626. Do I hear a motion? Aye. And a second? Representative Beck is ready to vote. And because of that, we will vote. All those in favor of attaching amendment coded 16626 to House Bill 630, please signify by saying aye. Those opposed, you adopt. Thank you, Representative Beck. Representative Gillespie, we are on your bill as amended. If you could, please describe it.
Thank you, Mr. Chairman and committee. I will be brief for you all. What this bill simply does is we have 2 different reports right now, the Vulnerable Adult Protective Investigative Team report and then the CPIT report involving child abuse, and it just aligns those 2 reports and creates a registry for those facilities that handle that population.
Members, you've heard the explanation of the bill. Do we have any questions for the sponsor? Seeing none, all those in favor of sending House Bill 630 as amended to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance.
Thank you.
Thank you, sir. That brings us to item number 5, House Bill 673 by Vice Chairman Freeman. Sir, you have a motion and a second. I also see amendment coded 16908. Do you wish to move that amendment, sir?
Yes, sir.
All right. Members, the amendment makes the bill, so all those in favor of attaching amendment coded 16908 to House Bill 673, please signify by saying aye. Aye. Those opposed, you adopt. Sir, we're on your bill as amended.
Thank you, Chairman and Committee. House Bill 673 expands confidentiality protection for victims of domestic violence, sexual assault, or stalking by restricting an advocate from disclosing communications from the victim without their consent in judicial, legislative, or administrative proceedings. This bill also allows the court to disclose information deemed relevant after a case review.
Members, you've heard the explanation of the bill. Any questions for the sponsor? Representative Griffey, you're recognized.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this legislation. I'm not fundamentally opposed to the purpose I think you're trying to accomplish, but again, my objections to this legislation is you're potentially going to exclude exculpatory evidence that a defendant has a right to present at a trial in his defense. If the bill was amended that would say any statements concerning identity, description of the alleged defendant, perpetrator, must be disclosed to the district attorney's office because they're ultimately responsible for getting exculpatory evidence to the defendant and as part of the court proceedings. I think I could probably support your legislation. I just, as it's written, you're going to protect all communications. And as a defendant or a defense attorney, you're not going to know what was said between the victim advocate and the victim. And, you know, some of those things may not ever come to the light of day. And that's what concerns me. And because first and foremost, I think our major concern is that nobody who's innocent of a crime ever gets convicted. And that's why we have the rules set up as we do, so that all exculpatory evidence must be made available to a defendant who's facing charges. So I wish we would think about amending the bill to carve out something where exculpatory statements or potentially exculpatory statements must be disclosed to the prosecuting district attorney in the case, so that protections can be provided and the balance can be maintained for protecting the victim, but also a defendant who's accused of a crime. If there's exculpatory evidence out there, they have access to it. So thank you very much, Mr. Chairman. Thank you, sponsor, for that.
Representative Griffey, thank you very much. Vice Chairman Freeman, you're
Thank you, Chairman. And again, I appreciate your comments and appreciate us talking about it and at depth in the subcommittee. And I'll repeat a little bit of what I said there. These victim advocates are not there for the defense. They are there to help the victim in their time of great crisis. The person being accused absolutely has a right to defend themselves against the accuser. And if the advocate were to make an accusation, they could have that information brought up in court. And then the second part is under Section C, and I'm going to read it. This section does not limit the ability of a court to compel disclosure if, upon the motion of a party, the court determines after an in-camera interview that, and then it runs through the information sought as relevant, material evidence, an alleged criminal act, the subject of a criminal proceeding. So in your example, if this person said, I was not there, can you have the victim advocate come and speak to the judge and define or describe the description of the perpetrator? If it didn't match, the judge could take that testimony and allow that to be heard in court. The intent of this bill, and I appreciate you appreciating and supporting the intent. The intent of this bill is to give the same protection that we give to doctors and lawyers and nurses and therapists to not have to come into court and testify against their client. These people are in a great moment of crisis and can say any number of things. I should have had that last drink. I should have been wearing whatever. I knew better than to go home with this person, and then have their own words in their lowest moment used against them. And I'll say it again: a person has no right at any point to be raped, regardless of if they're in the middle of the act, if they went to a place they shouldn't, they know they shouldn't have. You can be completely passed out and naked, and you do not have the right for someone else to lay hands on you. And if someone stands up, and again, because of the culture that we've created of this victim shaming, they say something that says, I knew better, it's my fault, and then their own words are used against them in a court case, that's not the intent of what a victim advocate should be doing. What I'm trying to do is protect them from having to go and testify against a person that 6 months earlier they were literally holding their hand and walking them through the process of getting a rape kit taken.
Representative Griffey for follow-up.
Thank you, Mr. Chairman. And I appreciate where your comments are coming from. And that's why I proposed perhaps if we tweak this a little bit so that we protect the defendant's right to exculpatory evidence, but at the same time protect the victim. I wholeheartedly agree with you. Statements like, I shouldn't have had that last drink, I shouldn't have been wearing what I was wearing, I passed out, so, stuff like that. And a victim should not be re-victimized by a defendant or defense attorney with statements like that. But here's where I'm concerned, because I can see this happen in reality. So, because of the relationship between a victim witness advocate and a victim, it can be quite close sometimes. The victim might remember certain things about the event later on after the fact. Perhaps what if the victim mentions to the victim advocate, I didn't get a good look at him, and this is later on, and the police have already taken their initial statement from the victim, but the victim later remembers, I just didn't remember that much about him, but I do remember there was a tattoo on his hand of something like that. And that statement's not shared with the police, but it's shared with the victim advocate. And then the person on trial doesn't have any tattoos on their hands. Suppose a victim later on with the thing, I don't remember much about him, and I totally agree with you. No one should ever be raped. That's horrible. I have 2 daughters. I'll protect them. I'll go to extreme lengths to protect my daughters. But suppose a victim later says, you know, he hit me, but I do remember he had these awful teeth. He just had these awful teeth. Suppose the defendant they have charged with this offense has a very nice set of teeth or something like that. But that statement, again, is not shared with the prosecution or the defendants. And so how is the defendant or a defense attorney going to know to make a motion to the court, hey, there's this additional stuff out there, these statements that we want to have access to, if they're never disclosed? You've cut off the ability of a defendant to even conduct a proper investigation. That's why I would submit that if we would require any statements that are exculpatory in nature that would potentially benefit the accused defendant, those must be disclosed to the prosecuting attorney because it's their responsibility to be fair to both sides. And that way it just wouldn't be a whole 100% the defendant and the defense attorneys gets every statement that's possibly made. But a prosecuting attorney has got an ethical obligation to disclose any and all statements. And this would, I think, protect both sides of the balance. So that's why I make that suggestion. And I can't support your bill in its current form, but I could support it if we amended it. And I apologize for coming up with this late minute. But we've had this discussion over a couple of years about this legislation, and I think I've been consistent in my position. So, but I appreciate the effort, and I support the concept and effort, but I'm worried about the loss of exculpatory evidence, and potentially somebody could get convicted of a crime that they didn't commit. So thank you.
Thank you, Representative Griffey. And I shared some of that concern as we went through subcommittee, and so I am curious to hear from the sponsor. Do you feel like, I know I think it's section 1, subsection C, says this section does not limit the ability of a court to compel disclosure if, upon the motion of a party, the court determines after an in-camera review, the information sought is relevant material, an alleged criminal act that is subject to a criminal proceeding, or an alleged act of abuse and neglect is the subject of proceeding. Do you feel that, because again, I shared some of these concerns, do you feel that covers that? I mean, do you feel like the defense attorney is probably going to trigger that motion every time?
Absolutely, and while I think that your comments are well intentioned, the percentage of these cases that ever actually get to court are extremely low. The amount of people that actually end up serving time is extremely low, and that is with the actual evidence of DNA, with the actual evidence of, photographic evidence of abuse, and the idea that an offhand comment in a moment of crisis of someone's teeth or last week's was weight or a tattoo is just not, it's not reality of how these cases end up working out. And furthermore, I fully believe that if they believed that there was a statement made of description, they could compel the court to have a testimony in front of a camera, and if there was anything in there, they could do it. To your point of the exculpatory evidence, I don't even, there may be a process currently for that to be reviewed, and if they have notes, for someone to review the notes and redact comments that are not exculpatory. But I believe, and again, after working with multiple stakeholders, this is the language that we came up with, and everybody at the table felt comfortable that this would absolutely satisfy your concern.
Okay. Next on my list, I have Leader Lamberth.
Thank you, and thank you for bringing the bill. I know we went back and forth on subcommittee. I'll be voting no today, and I wanted to share that publicly again. The communications are not made confidential as part of this bill. If it did, I'd support the bill. It says they're confidential in court only. So the advocate could literally go on Facebook and spread any of this information out all over the place, and then minus an in-camera, conversation with the judge, would not be required to come in court and testify. If we're going to protect the information, I just wish we'd go all the way and say, look, that's confidential, just like attorney-client privilege or anything else, but we're not. We're just saying it's confidential for purposes of court. And there's lots of exceptions in here for, it's not confidential if the advocate is being sued, and they can bring it into court. But in a criminal proceeding, just as was brought up, I mean, to say somebody just can't be subpoenaed, and it's allowed everywhere else, but it's just confidential in court, I just wish we'd gone all the way with it. And so because I don't feel like this truly protects that information, it's as much as you could get in the bill. I know you've shared that. And I applaud your efforts here. I mean, it is really an attempt at a really good bill. But unless we're going to truly make this communication confidential, I just can't vote for it. But again, everything you said earlier as far as protecting victims and their statements, there are already some statutes on the books that protect from some of that. No victim should have to go through that. But I just don't think this does that. So thank you very much for bringing it. I genuinely appreciate it.
Thank you, Leader. Do you wish to respond?
Yeah,
Sheriff
thank
Freeman?
you, Leader. And again, I also really appreciate you working with me on this and the consistent comments. And the requirement to disclose within court is a legal requirement. The requirement to not disclose in a public setting amongst doctors, lawyers, therapists is part of their personal code of conduct. It's not included in the TCA. And so including it just for the victim advocates would be actually doing them something different. And furthermore, if you look at, I shared some information with folks, there is, if you are a recipient of a VOCA grant or a VAWA grant, there are requirements that you cannot disclose. I mean, there are numerous areas within the code of conduct, within the code of ethics, that will not allow people to disclose that publicly. But none of those code of ethics or those grant requirements can not require them to testify in court against the person that they were supposed to be an advocate for. And that's why specifically it addresses that in this bill.
Leader Lamberth, you recognize for follow-up.
Thank you. And had the bill been limited to those that already have a confidentiality requirement, I would support it. The definition goes well beyond that, and I know we've talked about that, but I mean, it's volunteers, it's other individuals, it's those that are not licensed or have any ethical obligation to keep this confidential. If we were talking about those that have that responsibility, yes, again, I agree. Then it's just confidential across the board. But those are my concerns. Thank you, sir. I appreciate you addressing them.
Thank you.
Next on my list, I have Representative Hardaway. You recognize?
Thank you, Mr. Chairman. And that last exchange really addressed my initial question, but it also raised another question in my mind to pose to the sponsor. Why are we not going all the way?
Vice Chairman Freeman.
And I'm sorry if I wasn't clear in my description or answer a second ago. This is addressing a very specific concern, and that is that victim advocates are being called to court to testify against the victim. There are already requirements within the Code of Ethics, within grant funding, within HIPAA requirements, all sorts of restrictions that will not allow them to testify or to share this information publicly. And quite frankly, that's not the issue. The issue is not these victim advocates out posting on Facebook and telling everybody at the grocery store about someone that the person they're sharing the story with doesn't know about a case that they don't know anything about. That is not the issue. The issue is that that victim advocates are being called to court to testify against victims and forced to repeat things that the victim said in a great moment of trauma. And they are saying things that they may not remember, that can be used out of context, and the relationship is not in the form of a police officer answering a question or even a defense attorney asking them questions. This is someone that should have a complete feeling of trust to share anything, and then not have it used against them. So it's a very specific problem that we're trying to solve that is narrow, and that is why it's drafted the way it is.
Representative Hardaway.
Thank you, Chairman, and I wasn't clear on that, but I am now. So thank you for your answer. I'm supporting your bill.
I do have a list continuing here. I'll go to Representative Dixie and then back to you.
Thank you. For just have a couple questions. The victim advocate, it's a third-party organization, like a nonprofit organization that does not work for the defense or the prosecution, correct? Or
Vice Chairman Freeman.
That's exactly right. Yeah, they are, their sole responsibility is to the victim, not in the legal process.
Chairman Dixie.
So the victim's advocate is basically the first person that they see when they experience this trauma once they come forward and say, hey, I've been victimized or I've experienced this particular trauma. So they're basically still in shock of what's going on. So they're holding their hands basically through this process to say, hey, it's going to be okay. Because a lot of times victims in this particular issue or in this situation may be experiencing a lot of things. The offender may depend on that offender for financial reasons, for emotional reasons, a myriad of things. So by the time they get to court, things may have changed, or it's hard to even get them to come to court at that point. So the victim advocate, I just wanted to be clear that their role is just to support the victim throughout this process. They play no role in the actual legal process as we go through this.
Vice Chairman Freeman.
Yeah, that's exactly right. And they can sometimes there's a rape and sexual abuse hotline. There's a domestic violence hotline that a victim can call and have a victim advocate meet them on site to help them through the rape kit process, through any numerous. They're just there to help them as that process goes along. And they may not be with them long term. The switch after that initial intake, they could then get long-term treatment with a therapist, and that therapist would have confidentiality and could not testify in court as well. So there's no guarantee that the victim advocate could even be told any information specific. They could simply sit there, hold their hand as they get a rape kit taken.
Chairman Dixie, follow up.
Okay. Thank you, Mr. Chairman. Thank you, Vice Chairman.
And Vice Chair Freeman, I do, as we're sitting here, I'm genuinely listening to the debate here. I'm curious, when you're more familiar with these hearings than I am, but when these victim advocates are being called to court, are they not able to invoke their ethical obligation? I mean, can they just refuse to testify? Or
That's a fantastic question, and they are not. And so there are resources that have to be spent by these underfunded nonprofits to try and have those quashed, because they can be forced to testify on the location of where the victim is currently, where the testimony was taken, and in many instances, the location where that initial intake happens can be a domestic violence shelter, which is privileged information. We don't want people knowing where these domestic violence shelters are. So there are any number of reasons why we don't want that information, and absolutely they can be compelled to testify today.
Representative Griffey, ready.
Thank you, Mr. Chairman. And again, thank you, sponsor. I just want to run a hypothetical by you. Suppose a young lady gets drunk at a party, numerous people there. Suppose somebody roofied her drink or something, and she becomes incapacitated. And, after the incident, she's doing the best to remember. She tells the police, I'm 100% certain it's that person, that defendant at the party, rather than somebody else. And then down the road, after she's thought about it a month later and starts saying, she's like, I'm not sure that was him. And she tells that to her victim advocate. I'm really not sure it was him. I think it might have been the other guy that was there that I was kissing on or whatever like that. How is a defendant or a defense attorney ever going to get access to that information? Which is, if you were a defendant charged with a crime, go, it wasn't me. It was the other dude. But she's saying it's 100% it was you or me. that defendant is entitled to know, she's not sure. There was other statements she made that it may have been somebody else. This would shield that information from ever coming in from court, and there's no way a defendant or defense attorney is ever going to be able to make a motion to the judge, hey, judge, we want this information out there about these statements you made. They don't know what statements were made. They're not going to be able to make that motion. The judge is going to go, well, what's your basis for the motion? Well, I don't know. I just want to know everything they said. The judge isn't going to grant that motion. I think there's a better way to solve this problem if you simply say victim witness advocates cannot be compelled to come to testify to court about anything other than exculpatory statements or evidence. And victim witness advocates shall be required to give any exculpatory statements or evidence to the prosecution for purposes of the criminal proceedings. And that would, I think, solve the problem you're trying to address, but at the same time, we protect the rights of someone that might be wrongfully accused. So that's I won't say anymore. And thank you again for your, again, I appreciate the effort here, and I don't disagree with the effort. They shouldn't be called and dragged over the coals with stuff. We can stop that if we'll tailor our legislation to do that. So thank you very much, Mr. Chairman.
Members, any further discussion or questions? Representative Beck, you're recognized.
Thank you, Mr. Chairman. It's my understanding that if a shelter receives state or federal aid, that they are bound to confidentiality or they'll lose their state or federal aid. Is that correct?
Vice Chair Freeman.
Yes.
And I understand that you've worked with all the victim coordinators, and everybody's on the same page with this bill. Is that correct?
Yes, sir.
Great. Thank you so much.
Thank you, Representative Beck. Any further questions? Seeing none, we're ready to vote. All those in favor of sending House Bill 673 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? No. The noes have it.
Can I challenge that vote? Is that how that works? I'm just not sure.
A member of the committee would have to do that. Okay. Representative Hardaway, you recognized?
Thank you, Mr. Chairman. What's the procedure for challenging a voice vote?
We're going to take a brief recess. All right, we'll go back into session. We're back into session. The parliamentary situation we find ourselves in is that Representative Hardaway has challenged the ruling of the chair. That's a proper motion. Do we have a second? Second. We have a second. All those in favor of overruling the ruling of the chair signify by saying aye, and we will take a, okay, signify by saying aye. Aye. Those opposed? No. Motion fails. Thank you. All right.
Thank you, Chairman of the Committee.
Thank you, sir. Next up, that brings us to item number 6, House Bill 1855 by Chairman Doggett. Chairman Doggett, you recognize you have a motion and a second. I also see an amendment coded 17124.
Yes, sir, that's correct, and it makes the bill.
Excellent. All those in favor of adopting amendment coded 17124 to House Bill 1855, please signify by saying aye. Aye. Those opposed, you adopt. Sir, on your bill as amended.
Thank you very much, Mr. Chairman, committee. This amendment, or this bill, does two things. It clarifies the current penalties for continuous sexual abuse of a child. It does not change the current penalties, however, but it rewrites a section to simplify it. So, the change also amendment makes to current code is the addition of 2 offenses in the definition of sexual abuse of a child. Under the continuous sexual abuse of a child statute, those two offenses are trafficking for commercial sex acts if the victim is a minor, and also promoting prostitution if the victim is a minor. This change is going to allow prosecutors to charge these two offenses under continuous sexual abuse of a child statute, which allows multiple counts of these offenses to be tried together, limiting the number of times a child, which is very important, the number of times a child would have to testify and restate the abuse they suffered through multiple trials.
Members, you've heard the explanation of the bill as amended. Any questions for the sponsor? Seeing none, we're ready to vote. All those in favor of sending House Bill 1855 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thank you very much.
Yes, sir. That brings us to item number 7, also by Chairman Doggett, House Bill 1905. Sir, you have a motion and a second. I see amendment coded 17348. Do you wish to move that amendment?
Yes, sir, and this amendment makes the bill.
Sir, you have a motion and a second on your amendment. Without objection, we'll vote to get this on the bill. All those in favor of attaching amendment coded 17348 to House Bill 1905, please signify by saying aye. Aye. Those opposed, you adopt. We're on the bill as amended, sir. You're recognized.
Thank you, Mr. Chairman. What we are doing here is in TCA 381-101 in regards to reports to law enforcement officials of certain types of injuries. We're adding in the section after suffering from the effects of poison or suffocation, we're adding in fatal drug overdose to the extent allowed by state and federal law.
Members, you've heard the explanation of the bill as amended. Any questions for the sponsor? Chairman Halsey.
Thank you. Just make sure I know, is the amendment change it to fatality only?
Chairman Doggett.
Yes, sir, it does, and the reason for that is and I'm not a healthcare expert by no means, but you can take beyond the recommended dosage of Tylenol, and that could be considered an overdose. There's also certain criteria for facilities that they are limited as to the information they can provide. And so what we're doing is when someone comes into a hospital or they are on the street or in a home, whenever the case may be, whoever renders aid to this person, they have to report this fatal drug overdose to law enforcement, so an investigation can be done.
Chairman Halsey.
Thank you. I like the bill the way it was before.
I did too. Yeah.
I'll vote for your bill, but most of the time what you're dealing with, the intent of your bill is a controlled substance. And that's why the overdose, and I think law enforcement ought to be there. But anyway, thank you.
Thank you, Chairman Halsey. Next, I have Chairman Russell. You recognized?
Thank you, Mr. Chairman, and I agree with Representative Halsey. But my question is how will a hospital know this without an autopsy?
Chairman Doggett.
That is a good question. I guess they can learn this through interviews with the people that come in or come in with the patient. I can't answer that.
Thank you.
Representative Russell.
That's all I got.
Okay. Representative Griffey, you recognized?
Thank you, Mr. Chairman, and thank you, Chairman Doggett, for bringing this bill. Why can't we go with the original version of the bill? Have we got a problem with federal law with that version of it?
Chairman Doggett.
It encapsulates a lot more when you just have the singular drug overdose.
Representative Griffey.
What if it was, I thought the original bill was limited to controlled substance like Representative Halsey mentioned, fatal overdoses of controlled substances. Am I incorrect in that?
Chairman Doggett.
The original language said, or drug overdose.
Okay. Representative Griffey.
Would a smarter amendment maybe be that we limit the bill to overdose of illegal controlled substances? Perhaps.
Chairman Doggett.
I'm at the will of the committee. If that's the will of the committee to make an amendment to do that, I'm okay with that.
I will mention just briefly, because I know we've had a question from Chairman Russell and also now from Representative Griffey dealing with some of these kind of more granular issues. We do have available for questions Elizabeth Foy and Olivia Spears from the Department of Health. We also have Zach Blair on the list to testify if necessary. So I'm not encouraging the committee one way or the other, but if there are more granular, more technical questions that you'd like to ask of those folks, they are here and available, but I'm at the will of the committee. So Representative Griffey, you're recognized.
Mr. Chairman, I make a motion we go out of session and let's hear from some of the health department. I'd like to get a little more detail because I think the intent of the original bill was, look, if you have someone overdosing on controlled substances, illegal drugs, the sheriff's department needs to know that, and because that can save the lives of so many other people in the community if they can get this information and quickly do their investigation and so forth. So if we're got a problem with federal law, we're going to have to comply with that probably, but it would help to know sort of where we are trying to match up these two interests.
Okay. Without objection, we will go out of session. And again, I see Mr. Zach Blair here. He is on my list for testimony. And then Ms. Foy and Ms. Spears, if you want to come down, everybody, you can all take your seats. I guess, Mr. Blair, we'll start with you. If you could just make sure your microphone's on, share your name with the committee, and then testify however you'd like.
Thank you, Chairman. Zach Blair with the Department of Mental Health and Substance Abuse Services. Want to thank Chairman Doggett. We've worked with him the last several weeks on this particular bill. The original concern as drafted is there is a federal law, 42 CFR Part 2, that generally protects the confidentiality of records related to any type of substance use treatment, and it further goes to say that in cases where there's a law enforcement interaction, it is trying to protect that information so that someone does not feel like they cannot seek treatment and end up being part of a criminal investigation. So the way the bill was drafted originally, it applied to any setting, any circumstance, any body. And there were concerns that there would be many cases where this would conflict with 42 CFR Part 2. And 42 CFR Part 2 goes on and even says in the language of the regulations that there's no state law can compel the disclosure of this information without the consent of the patient or the patient's legal representative. When Chairman Doggett agreed to amend to limit it to fatal overdoses to the extent allowed by state and federal law, this both protects 42 CFR Part 2 information if it exists in that facility, and it also alleviates any concern about someone maybe not seeking medical attention if they believe they were going into an immediate interaction with the criminal justice system. That's why we're deferred on this amendment as it has been drafted and adopted by the committee.
Members, any questions for Mr. Blair? Representative Griffey, you recognized.
Thank you, Mr. Chairman. Mr. Blair, is 42 CFR limited to treatment?
It is any facility or provider that receives federal assistance and holds themselves out or is part of a facility that offers some type of substance use disorder treatment. So there are many cases where hospitals, even hospitals that don't directly offer substance use treatment in that facility, may be attached on the same campus to those facilities. And also the way the bill is drafted in its original form, the bill does not limit it to a facility type, which could catch Part 2 facilities if someone were to walk into a substance use treatment, a medical detox situation, and an overdose led to that notification as outlined in the bill. That could conflict with federal law in those circumstances. There are also a lot of hospitals that do offer some form of substance use disorder treatment.
Representative Griffey.
Thank you, Mr. Chairman. So is a person actually seeking treatment if they OD on meth, fentanyl, whatever it is, and they're having to be transported to the hospital? Are they actually seeking treatment at for drug addiction?
So the 42 CFR Part 2 talks about the facilities where that happens, and that's when the records become confidential. So a current or previous diagnosis of substance use disorder requires patient consent for notification to go outside of the doctor-patient situation. It also requires that consent for further disclosure after that disclosure can be made. So that's probably arguable whether or not they're seeking treatment at that situation. In a lot of circumstances, fortunately and unfortunately, that near overdose, if it's not a fatal overdose, can lead to someone seeking treatment. We have a program called the Tennessee Recovery Navigators that they actually go to the hospitals, and if they have an overdose situation, we talk and engage them into trying to get to treatment. So there are circumstances where that can lead to a treatment success story, luckily.
Representative Griffey.
Thank you, Mr. Chairman. So here's my point. If a person ODs on fentanyl or whatever, the ambulance is called. Most of the times the sheriffs are called, so forth. I mean, it's really not confidential whether the person OD'd on a drug, had a drug overdose or not. I mean, it's really no secret at that point. There's really no confidentiality as to that material fact. And I think what the purpose of Chairman Doggett's legislation is that healthcare professionals and others, first responders, are concerned about the liability of possibly disclosing that information to law enforcement, which I think that's relevant information of a non-confidential material fact that they need for further investigation. And I haven't gone through in detail, line by line, the language of Part 2 on 42 CFR, but I just kind of wonder whether we're being overly protective and concerned about possibly impinging on a federal regulation or not. And maybe you can comment on that.
Mr. Blair, you recognize?
Yes, sir. And we've talked about several issues, making it specific to not apply to Part 42 facilities in those situations. There are approaches. I think when we spoke on Monday with Chairman Doggett, the fatal overdoses where people are losing their life because we're not aware of either what they're taking or they were. I know we've used the term they were poisoned by somebody. That is certainly something that we want law enforcement to be able to cut off the supply, but we also don't want our practitioners and facilities to face the criminal penalties outlined in 42 CFR Part 2 if they meet those requirements under the federal law.
Representative Griffey.
Thank you, Mr. Chairman. I'll wait to hear from the other guests, please.
Next on my list, I have Chair Lady Moody. You're recognized, ma'am.
Thank you, Mr. Chairman, for letting me do this at this time. Members, I have a dear friend in the audience. He is Colonel Jason Fleming and has served our country honorably. He's from Tifton County, and he's sitting with us today. Will you give us a wave? Thank you for being here.
Thank you, sir, for being here. Thank you, Chair Lady Moody. And now I'm going to go to the sponsor of the bill, Chairman Doggett. I believe you had a response or a comment on that exchange.
Yes, sir. Thank you, Mr. Chairman. In response to representative from behind me here, what the intent is, and this may be out of order since we're out of session, but right now, law enforcement, if someone and I think we think of overdose as you've died from taking drugs. Something in your system has killed you. When you hear people died of an overdose, we don't always think, or at least I don't, circles that I run in, think of it as an overdose as taking more than the prescribed or more than the recommended dosage of something, whether you do it accidentally or intentionally or what have you. But right now, law enforcement is notified if you have a drug overdose and you die in a ditch on the side of the road, law enforcement is going to be notified. They're going to be there to investigate. If you die in your home and someone calls 911 of a drug overdose, law enforcement is going to be notified and they're going to be there and they're going to investigate. However, if you go to the ER and die at the ER with a drug overdose, law enforcement is not going to be notified. And so that is what the intent is to be able to notify law enforcement that this has happened, because in all other circumstances, law enforcement is going to know. They're going to be there to investigate. And so that was the meetings that we've been having over the last couple weeks. We tailored it down to that's what we were looking at. That's what we were trying to get at and add a tool to law enforcement, but also be able to add another weapon that we could use to defend our communities from drugs such as fentanyl that are running through my district prevalently right now because of the ease and accessibility that we have created. Well, not we, but that's happened across this country. That fentanyl is coming. So that's what the intent is what I'm trying to do. And there is a section in TCA 63-1-156 that does provide immunity to persons who come into hospitals that are seeking medical assistance because of a drug overdose. Those people are living and breathing. But we want to be notified when those persons are not alive, when they fatally overdose and come to the ER, so law enforcement can go forward. Thank you.
Thank you, Chairman Doggett. Next on my list, I have Representative Chairman Russell. You recognize?
Thank you, Mr. Chairman. This is Mr. Blair. 42 CFR Part 2, does it deal with prescribed medication or illegal drugs, or both?
Mr. Blair, you recognize?
Thank you, Chairman. Chairman Russell, this would apply to substance use disorder treatment. So if someone is seeking treatment, whether that be a legal or illegal substance that they're addicted to, 42 CFR Part 2 is comprehensive of the records related to that.
Chairman Russell.
Okay, has there been any sort of a legal opinion or Attorney General's opinion to see if this bill would conflict with 42 CFR Part 2?
There has not been a request that I'm aware of, Chairman Russell, from either the members or our agency to ask the Attorney General to opine on this particular language.
Chairman Russell, you recognize?
If that's the case, how do you know it would conflict with federal regulations?
Mr. Blair.
That was based on our legal analysis with our experts in the department that deal in this field from a legal perspective on a daily basis.
Chairman Russell.
Has this been done in any other states that they got that idea from or opinion from?
Commissioner Williams actually asked her counterparts that she works with on a national level. We are not aware of another state law where overdoses are disclosed in this manner in the country, and we asked that question specifically because we did want to know how other states were addressing this.
Chairman Russell.
How would law enforcement know about this if they didn't get how would a hospital know without an autopsy that the person died from an illegal or a substance abuse problem?
Mr. Blair.
So an individual that presented it at the ER, I think the signs and symptoms of overdose and the resulting problems medically that patient would have, I think our doctors in Tennessee, unfortunately, are very well versed in overdose and see that on a regular basis. Sadly, I mean, in 2020, I believe it was over 3,000 people that suffered a fatal overdose in Tennessee. So this continues to be a common thing that happens in our state that we are trying to fight every day. And sadly, I'm afraid that our medical professionals experience and understand it very well and would know pretty quickly if someone did come to the ER if that an overdose is occurring.
Chairman Russell.
But they couldn't be 100% sure without the autopsy, correct?
That is true, but I don't think there's anything in this bill because of the immunity granted to the providers later on in that same statute that would cause them any potential issue if they were to report in the case of a suspected overdose even.
Chairman Russell.
So if there's a suspected overdose, it's my understanding they can go ahead and order an autopsy. Is that correct?
Mr. Blair.
That would not be something that I'm familiar with, Chairman. I'm sorry.
Chairman Russell.
If an autopsy was ordered from whoever, and that report is automatically sent back to the district attorney, they would already know this information from that report, right?
Mr. Blair.
And Chairman, I apologize. I'm not familiar enough with the medical examiner process or autopsies in Tennessee to know exactly what is sent, what's given, and what information they would have access to.
Chairman Russell.
And earlier you said that the original bill would lead to someone not seeking treatment. Is that correct?
There were concerns about that, Chairman Russell, that the fact that it was an automatic report in any overdose case, no matter if it was an illegal drug or the setting, that somebody may look and say, hey, I've had an overdose already, because people do overdose multiple times and fortunately don't die. But they may say, hey, I've had an overdose already. The immunity doesn't apply to me. So they may be concerned about going into a medical facility because there is concern that they may have interaction with the criminal justice system as a result.
Chairman Russell, you recognized.
With that being the case, if a law enforcement office was notified of suspicious activity, drug activity, overdoses, or whatever the case may be as defined in the first bill, wouldn't it be better if a law enforcement office could go out and investigate that and lives would be saved that way versus leading to someone to seek medical treatment would be an issue?
Mr. Blair, you recognize?
So I think the starting point, just from us, from a policy perspective, is the worst outcome that can happen is that individual die. And any barrier that would potentially lead to a person succumbing to that overdose, whether that be either not seeking medical attention or acting in an irresponsible way that leads to an overdose, that's always the starting point for us. What can we do to hopefully prevent people from succumbing to a drug overdose? Let's keep them alive enough to where we can engage them and get them into treatment. And obviously, we want law enforcement, because we can as an agency. We want law enforcement to be able to get to and cut off that supply. It's very, very important. But we also just want to be sure that there are no unintended consequences, both from the provider's liability, the facility's liability, and also for the individual seeking that help if they find themselves in this situation.
Chairman Russell, you recognized.
So under current law, people are already dying at record numbers. So would you not think that we would need to change it?
Yes, sir, and I think that's why we have brought a number of pieces of legislation in the last few years that are focused on overdose. There are several that are there now. A bill that our department asked to come and propose to you that came through this committee is something that we think is very important. Narcan distribution that we use with our both state and federal funding to get that out in the community. Those are very, very important things that the General Assembly continues to approve, fund, and allow us to do to help try to stem the tide in overdoses.
Chairman Russell, you recognized.
So is opioid deaths rising or decreasing?
So I have not seen the most current numbers for 2021. I'm not sure if that report is out yet. The last time I checked, and the Department of Health does the overdose report. But yes, they have consistently risen. Overdose related to fentanyl opioids have risen in the last several years, absolutely, throughout the country.
Chairman Russell.
With that case, it appears to me that the previous legislation this body has passed is apparently not working, so I think we need to try something else, and I would rather do the first bill without the amendment, but that's all I got.
Members, we also have Elizabeth Foy and Olivia Spears here just to remind everybody, so if you have any questions for them as well, we do have an expert panel here, so I will go next to Chairman Holsey. You're recognized.
Thank you, Mr. Chairman. I was just going to make the point. I don't, in 36 years of police work, we handled lots and lots of overdoses, some of them accidental, some of them intentional. It's not against state law to try to kill yourself. I don't know of one time, and maybe it's happened someplace, but I don't know of one time anybody prosecuted somebody because they were in an emergency room overdosed. I just never saw that. The other side of it, we do have a statute that says if you sell drugs to somebody and they die, that's second-degree homicide. And, of course, there's no way to investigate that adequately and get involved in the middle of it to pursue charges on it if you don't have access to the information on the front end. So that's the only point I was making.
Next on my list, I have Representative Griffey.
Thank you very much, Mr. Chairman. Mr. Blair, let me ask you this. It seems like under Part 5 of 42, Part 2, it says, crimes on Part 2 program premises or against Part 2 program personnel. The restrictions on disclosures and use in the regulations in this part do not apply to communications from Part 2 program personnel to law enforcement agencies or officials which are directly related to a patient's commission of a crime on the premises of a Part 2 program or against a Part 2 program personnel or a threat to commit such a crime, and are limited to the circumstances of the incident, including the patient's status of the individual committing or threatening to commit the crime, that the individual's name, address, and the individual's last known whereabouts. So it seems to me, let me ask you this, it seems to me like if we made it an offense for anyone to show up in an unconscious state with vital statistics indicating a threat to their loss of life that appears to be from a controlled substance such as opioids, fentanyl, whatever, if that was an offense, if someone shows up to emergency room like that, we wouldn't have any problem with Part 2, would we?
Potentially not, but I think at that point, Chairman and Representative Griffey, you'd be criminalizing overdose at that point, and that would be something that we'd be very, very, very concerned about.
Representative Griffey.
And it is actually a crime to try to commit yourself in Tennessee, kill yourself in Tennessee, isn't it? Commit suicide, you can be locked up for that.
That's a good question. I don't know the answer to that, but in these circumstances, I would say that most of these individuals are not seeking to die.
Representative Griffey.
Thank you. Well, Mr. Blair, this is sort of my problem. I understand where you're coming from. The Department of Health and the folks with mental health and substance abuse, you guys sort of have a policy position perspective that you think if we criminalize and require people to report this is going to discourage people from showing up to get mental health treatment or something like that. I get that. But that's a policy decision that this legislature is supposed to make, not you all. I mean, I get it. You're more entitled to make your opinion and voice your concerns about it. But honestly, this is a decision for the legislature to make. What's the best policy? What's going to be effective for the citizens of Tennessee to save more lives?
Okay. Representative Griffey, if I may interject here, the situation we find ourselves in is that House Bill 1905, presented by Chairman Doggett, is before us. Both of these witnesses, I believe, are here to say that they are neutral on the bill and to answer any technical questions that we have. So we have been spending about 25 minutes of our time on a very full calendar beating up witnesses for a bill that they do not oppose. Just want to remind everybody of that. All right, we are back in session. Question's been called. All those in favor of sending House Bill 1905 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Not a no vote in the House. That brings us to item number 8, House Bill 2762 by Chairman Doggett.
Thank you, Mr. Chairman. I have another quite controversial bill here, so look forward to that.
Before you get started, I do need a motion and a second. We have a motion and a second on this bill. I see House Criminal Justice Committee Amendment number 1, which is coded 14932. You wish to move forward with that amendment?
Yes, sir, I do.
All right. We have a motion. Do I hear a second? All those in favor of attaching amendment coded 14932 to House Bill 2762, please signify by saying aye. Aye. Those opposed? Now we have amendment coded 17349. You wish to move that as well?
That is correct, yes, sir.
Do I hear a second? All right. All those in favor of attaching amendment coded 17349 to House Bill 2762, please signify by saying aye. Aye. Those opposed? And now we will roll both of those amendments into one. Chairman Doggett, we're on your bill as amended.
Thank you so much. What we are doing is codifying the current pay scale practiced in the District Attorney General's Conference and the Public Defender's Conference for assistant DAs and assistant PDs. We're also removing the cap on prior service credit for private practice of law used to determine entry-level compensation for ADAs and ADPDs.
Members, you've heard the explanation of the bill as amended. Any questions? Representative Hardaway, you're recognized.
Thank you, Chairman. And to the sponsor, how equal will the DAs and the PDs, assistant DAs and assistant PDs be in compensation with this?
Chairman Doggett.
If I am correct, we are exactly the same. An assistant public defender and an assistant district attorney make the same amount for that, whatever year of service that they're in.
Representative Hardaway.
That's fair, and I'm supporting your bill. I might
you.
vote twice.
Might vote twice. Very good. Okay, seeing no further questions, all those in favor of House Bill 2762 as amended, please signify by saying aye. Aye. Those opposed? Sir, you head to finance.
Thank you.
If you wish to vote twice, you have to move to Chicago. Hey! Members, that brings us to item number 9. House Bill 2524 is rolled to the heel of today's calendar. And for the next couple of items, I will pass the gavel down to our Vice Chairman.
Thank you, Chairman Curcio. We have item number 10, House Bill 325 by Chairman Curcio.
Motion.
I have a motion and a second, and you are recognized.
Thank you, Mr. Chairman. I have an amendment that makes the bill. It's coded 14663. I wish to move that amendment.
I have a motion and a second on the amendment. No objection. All in favor of adopting this amendment, say aye.
Aye.
Opposers? There's none. The amendment goes on to the bill. You are recognized on the amendment.
Thank you, Mr. Chairman. Thank you, committee members. This bill sets up what is called the EMIF Task Force. Since I have been in the General Assembly, we have had a bill every year to fix or otherwise tweak the EMIF fund. This is the Electronic Monitoring Indigency Fund. And we still have not successfully fixed it, unfortunately. So every year, the cure seems to be worse than the ill. I've worked for a number of years to try to get to work with the administration on an administration bill to iron this out. And so this effort, House Bill 325, although I hope this would be the vehicle to fix this issue once and for all, I think it will lead to that, which is it creates the Electronic Monitoring Indigency Fund Task Force to study and make recommendations on the future of the Electronic Monitoring Indigency Fund. And with that, I'd be happy to answer any questions.
Representative Dixie.
Thank you, Mr. Chairman. And to the sponsor, we passed a bill about the interlock earlier this week. Would they be able to use this fund too, or is this simply for the GPS monitoring?
Thank you, Mr. Chairman. Great question. The way the fund is currently structured, Interlock has sort of first dibs on the money that comes in. Whatever is left over then flows over into the Electronic Monitoring Indigency Fund. So we do view those as two separate pieces of technology, if you will. But right now, the fund is coupled. What this bill simply does is studies that fund to try to make recommendations on how to modernize it. So if I had my preference, I would like to separate out Interlock and see all other forms of technology treated in the EMIF and Interlock be by itself. But that is exactly the purpose of this task force, is to make those types of recommendations.
Representative Dixie.
Do we know what the total of that fund is right now that the Interlock has that flows over? I remember a couple years ago it was like $1 million, and I'm not sure what it is now.
So if you're asking what's appropriated for it, or what?
Yes, sir.
I don't think I have that number off the top of my head, but we could probably find it out.
Thank you.
Okay.
Any other questions? If not, we're voting on House Bill 325. All in favor say aye.
Aye.
Opposers? None. The motion moves on to GovOps.
Thank you, Mr. Chairman. Thank you, committee.
Brings us to item number 11 by Chairman Curcio also. It's House Bill 2040. I have a motion and a second. I think we have two amendments. You want to adopt which one?
Thank you, Mr. Chairman. I wish to move the amendment coded 17291.
I have a motion and a second to adopt Amendment 17291. All in favor say aye.
Aye.
Opposers? The amendment goes on to the bill. You are recognized on the amendment.
Thank you, Mr. Chairman and committee. Members, this bill did pass out of subcommittee, but we noticed a number of minor changes that needed to be made. I'll try to highlight just a couple of those. Number one, we wanted to tighten the definition of monitoring company to make sure that it did not encompass the manufacturer of these devices. So there are manufacturers that make, say, a transdermal device, but in various states, there are folks who are more or less their sales team, or they own a franchise to be able to sell those devices. Those are the folks that we are wanting to make sure that we create some uniform standards for, not the manufacturers themselves. They're already covered under other sets of laws. And so we also wanted to make sure that we tailored this so that it properly acknowledged the role of these monitoring professionals. But again, this bill, as amended now, seeks to provide a baseline standard for the folks that would engage in this business activity in Tennessee. I believe personally that these technologies are vital. I think they're going to continue to bring us savings and efficiency in the criminal justice system, but we've got to make sure that the folks who are monitoring offenders in our criminal justice system are in fact doing the work properly, and that's what this bill seeks to ensure.
Thank you, Mr. Chairman. Any questions? Seeing none. Question's been called on the bill. We're voting on House Bill 2040 as amended. All in favor, say aye.
Aye.
Opposers, no. That bill passes and goes on to finance.
Thank you, Mr. Chairman and committee.
Brings us to item number 12, House Bill 2102 by Chairman Curcio.
Second.
We have a motion and a second. I believe there's an amendment.
Yes, sir. There's an amendment coded 14285. I wish to move.
I have a motion and a second on the amendment. That's the coding number that I have. All in favor of putting this amendment on the bill, say aye.
Aye.
Opposers, no. The amendment goes on to the bill. You are recognized on the bill as amended.
Thank you, Mr. Chairman and committee. Members, this bill actually came to me by Chairman Howell's district attorney. And it pointed out we've done a lot of reforms on expungement over the last several years, and one bill in particular last year that this body saw fit to pass and became public chapter. And it was pointed out to us that we did not include those same offenses prior to 1989, which is, of course, the last time we did the major adult sentencing overhaul. And so this bill would simply apply those exact same standards, if you will, to folks who committed those crimes prior to 1989. With that, I'd be happy to answer any questions.
Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. And to that point, again, just for the record, the intention of this bill then is to include crimes that are on the books after 1999 that we have made expungible for first offenders and all other criteria they would fit into. But if that exact same crime just maybe is named a little differently on crimes prior to 1999, it's intention that those crimes and those crimes only would be expungible. Is that accurate?
Chairman Curcio.
Thank you, Mr. Leader, for the question. Thank you, Chairman. Absolutely. That is exactly the intent. We're not seeking to do anything different than that. And just as a reminder, not to get wrapped around the axle on this, but this committee worked very hard on that expungement legislation last year. It's one crack at the apple. And, you know, we kind of have different, you know, levels, burden of proof, if you will, and rebuttable presumptions either way, depending on what level of offense you're talking about. So very carefully crafted, just unfortunately didn't grab those folks prior to 1989.
Leader Lambert. Any other questions? If not, we're voting on House Bill 2102 as amended. All in favor say aye.
Aye.
Opposers, no. The ayes have it. Moves on to calendar.
Thank you, Mr. Chairman and committee.
All right, that brings us down to item 13, House Bill 2329. I have a motion and a second. Excuse me, we have an amendment.
Yes, sir.
Would you give me the drafting code?
Yes, sir. It's amendment coded 16697.
Okay, can we get a motion and a second on the amendment? Okay, all in favor of adding the amendment, say aye.
Aye.
Opposers, no. The amendment goes on to the bill. You are recognized on the bill as amended.
Thank you, Mr. Chairman, and I appreciate your indulgence as we've gone through the Curcio calendar here since item number 10. This bill, as amended, would deal with various computer crimes. So this section of code has not been updated in many years, and as we all know, you know, these devices that we carry around with us, along with, you know, our crafty folks that would seek to hack into them change on a daily basis. And so this is a modernization of this section of code to really put some teeth and enforcement into things like, attaching malware to someone's computer, those sorts of things. Be happy to answer any questions.
Question's been called on the bill. We're voting. Excuse me. Okay, Representative Hulsey.
I'm sorry to delay. I mean, there's a bunch of barbecue up on 8th floor, and I want to get there, so I really do apologize for being late here. Does this affect or involve telephones, cell phones, as well as computers?
Thank you, Mr. Chairman, and thank you, Chairman Hulsey. So let me just run through briefly what the bill does. So the bill as amended increases the penalties for certain offenses that are already a crime up to a Class A misdemeanor. It creates a new Class A misdemeanor offense of possessing a computer contaminant, otherwise known as malware, and then it deletes a redundant section of code that deals with the transmission of electronic signals. As far as telephones themselves, I think... All right, so if we look at the definition of computer, which is already in code, that would include a telephone device, is that?
In the bill itself, I see the words telephone, but in the explanation, it was only computer. That's why I was asking, and I'm sorry, Chairman.
No, not at all. Mr. Chairman, I would request that we maybe go out of session and just clarify whether or not telephone is included in the definition of computer.
Without objection, we're going out of session.
Michelle Fogarty, Legal Services. Computer is defined as a device or collection of devices, including its support devices, peripheral equipment or facilities, and the communication systems connected to it, which perform functions including but not limited to substantial computation, arithmetic or logical operations, information storage or retrieval operations, capable of being used with external files, one or more operations which contain computer programs, electronic instructions, allows for the input of data and the output of data. Such operations or communications can occur with or without intervention by a human operator during the processing of a job.
Any more questions for legal? Leader Lamberth.
Thank you, Chairman. And Chairman, while the Vice Chairman has the mic, I'm going to mention something here from Ms. Fogarty. I would like us to all give you a round of applause for your service this year, and I mean it. And I say that at this point because, Representative Griffey, myself, others, practice law, and we will spend days, weeks, or months looking up answers just like what you just found in seconds and rattled off. It is literally one of the most difficult legal jobs on the planet, and you do it very well. So I wanted to take this opportunity. I'm sure the chairman will brag on you later, but to just highlight that fact. So thank you very much.
Thank you.
Okay, any other questions for legal? If not, we're going to go back into session, and we're going to go back to Chairman Curcio.
Thank you, Mr. Chairman. And to Chairman Hulsey, I think what we heard there in that definition certainly would apply to a smartphone. Now, if you're talking about the phone that's screwed into the wall at my grandmother's house that only makes phone calls, I don't think this is the section of code that deals with that. But everything else that we heard that would certainly would describe this supercomputer that I'm holding in my hand that also happens to make phone calls. So, yeah.
Yes. Any other questions? If not, we're voting on House Bill 2329 as amended. All in favor say aye.
Aye.
Opposers, no. The ayes have it, and it moves on to calendar and rules.
Thank you, Mr. Chairman, and thank you, committee. Thank you very much. And members, we do have quite a bit of business yet to get to, although before I do that, I want to take a point of personal privilege. Leader Lamberth is very crafty on his smartphone that's in his pocket most of the time. And I think it's fitting that we deal with this presentation right after you've held the gavel. We have a gift here for Vice Chairman Sexton.
Gives me
I have a question, Mr. Chairman.
You are recognized, sir.
Who heard me say that today? No, I didn't say it today. I've said it other days, but not today.
I cannot take credit for that. Leader Lamberth was able to source that from a very special place. We hope you wear it with pride after you leave here.
I will get even.
Excellent. All right, members, that brings us to our cannabis calendar. Item number 1, House Bill 2641 by Chairman Terry. Unfortunately for Chairman Terry, that bill did fail in Senate Judiciary, so it is off notice. That brings us to item number 2, House Bill 1747 by Vice Chairman Jernigan, who I do see in the room. Sir, you have a motion and a second. I see no amendments. You are recognized on your bill.
1 second here. Thanks, Lee. Okay, thank you for your patience, Chairman. Members, House Bill 1747 adds quadriplegia to the list of qualifying medical conditions listed in 687201. This will allow for Medical Cannabis Commission to study the effects and give lawful possession of cannabis oil to Tennesseans with quadriplegia. It would also include veterans with quadriplegia, which is a bill that Colonel Wendell had earlier on the last calendar. It would include those as well. The current diagnoses that are on the list right now are Alzheimer's, ALS, cancer, Crohn's, epilepsy, multiple sclerosis, Parkinson's, HIV, and sickle cell. Adding quadriplegia to the list would help with most side effects that are living with quadriplegia, or severe muscle spasms, chronic pain, overactive bladders, and insomnia. So I live with quadriplegia every day, and I'm in a chair sometimes 14 hours a day. And at the end of the evening, my legs get very stiff, and they have severe spasms at night. And on the average, I can have insomnia most nights. My physiatrist seems to think that cannabis oil would help a lot. I've exhausted all conventional methods for treatment. I don't smoke marijuana. I do not want to get high. Just not interested in that. The Department of Safety has deferred on the bill. And, Chairman, I'm happy to say, unlike Terry's bill, it did pass judiciary. Senate 6-3 is going to the Senate floor. So I'm asking the committee for some relief for Tennesseans with quadriplegia and to be added to the diagnosis, to study for the commission. And with that, Chairman, I'll be happy to answer any questions.
Thank you, Vice Chairman Jernigan, and for the committee, I just do want to confirm this bill has passed Senate Judiciary. I understand it's been calendared for the full Senate vote tomorrow on the 14th, so just as a clarification. I do have a list building. First, I have Vice Chairman Sexton. You're recognized, sir.
Thank you, Mr. Chairman. Chairman Jernigan, I just want to say that I'm not going to be here next year. I may never have another chance, and I think this is a good opportunity for me to tell you what an inspiration that you are in everything that you do, and seeing you get around and see how hard that you work. And as far as your bill goes, I think that anything that is on God's green earth that's been given to us, we ought to be able to use it for the benefit of good. It's up to everyone how that they use substance and drugs or whatever the case might be, to use it good or to use it for evil. And I do think that you ought to, and anyone ought to have the opportunity to try things that's been given to us, as I've said, from God above for the benefit of the good that they might bring. And so I'll be voting yes for your bill. And I'll be voting yes for you because I appreciate you and all that you do.
Thank you, Vice Chairman Sexton, you wish to be recognized, Chairman Jernigan?
No, I'm grateful for your comments. I appreciate you saying that. Sometimes it's hard to I appreciate that when people say that it's inspiring, but it's the cards have been dealt to me. I'm playing them, and we all have issues in our lives, and we wake up, and I'm happy to serve with you. And we came in together, I believe, and along with Leader Lamberth, and I'm going to miss some people I know that I came in with, but thank you for your comments. I appreciate your support, and you'll be missed down here as well.
Thank you. Next on my list, I have Chairman Halsey. Recognized, sir.
Thank you. Jerry Sexton doesn't have an office across the hall from you, so he don't know what kind of harassment you can deal out. So I want to make that clear. I had one question. It doesn't affect how I'm voting, but I just had a question. On the other maladies that this can be used, is there a maximum of THC content? Because I don't remember that, and it's not in your bill. Who regulates that, or who calls that shot?
Vice Chairman Jernigan.
I believe there is. I would have to defer to legal about what that is, if you don't mind.
And we can certainly do that. It's 0.9%. That's right. That's under this type. That's right.
Thank you.
Any further questions for the sponsor of the bill? Seeing none, we're ready to vote. All those in favor of sending House Bill 1747 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules, and before you leave, Leader Lamberth, you're recognized.
Mr. Chairman, Representative Jernigan can leave. It's not about him. It's up to him whether he stays or goes. He may want to stay for this,
I'm sorry,
though.
I thought you had a question.
No, I said my just personal privilege here. We had a member a while ago that mentioned the fact that he might have to leave and abandon our committee because there was barbecue on the 8th floor. And Representative Halsey, Lucas, stand up for us here. Come on. Lucas here is an intern down here at the legislature, and I texted my assistant and asked Lucas if he would come. Halsey, here you go, buddy. It's barbecue from the 8th floor. There you go, man. So thank Lucas there. All right, no problem.
I feel like there's a joke about passing out pork during budget season, but I don't know what it is. But yes. All right. Thank you, Chairman Jernigan. Members, that brings us to item number 3, which is House Bill 1927 by Leader Lamberth. Sir, you have a motion and a second. I also see amendment coded 17338. You wish to move that amendment, sir?
Yes, sir, Mr. Chairman.
You have a motion and a second. Members, let's go ahead and get that amendment on the bill. All those in favor of adopting amendment coded 17338 to House Bill 1927, please signify by saying aye. Aye. Those opposed, you adopt. And we'll go ahead and let's withdraw amendment coded 15310. Without objection, withdrawn. And now, Leader Lamberth, we are on your bill as amended.
Thank you, Mr. Chairman. Members, as we've gone through this process over the last several weeks on this bill, I've heard from several members of the community and our fellow Tennesseans, hundreds of folks that have emailed, called, I've met with, and many of you have as well. And I appreciate that input and feedback. When we began this, my main question to folks was this: how do we make sure that Tennesseans are safe? With these products on the market, how are they regulated? How are quality controls done? How do we make sure that a child is not overdosing on a substance that looks like any other gummy bear that they've ever picked up in their life, and yet it is not? It is a very different substance. And I made a ton of notes on that. I mean, you guys have seen kind of my scribbled on pages up here. Every single conversation I've had. I've called many folks that have emailed me. I've called them on the way home late at night. I appreciate them taking my calls well after hours. But I've tried to listen and learn as to what exactly these different substances are. How can they be utilized properly and not put people in danger? And that's been my biggest question, because I know for this committee, and you all know my main goals are to make sure that Tennesseans are safer after every session than they were when we began. That's the goal. So this amendment does, I believe, just that. And so both with the bill that we passed a couple of years ago and the federal farm bill, it has left all of these vendors and, quite frankly, their customers of any THC product in a very murky and unusual predicament, because there are certainly no regulations. There are no, legitimate ways for a consumer to be able to know exactly what they are buying. And unless just a vendor chooses to do so, out of the goodness of their heart, and because their business model requires that, which I applaud those that have, a 7-year-old could literally walk into any gas station or retail store right now and buy a package of high THC material and consume that. Now, I would hope that no one would sell to a child this, but there's nothing in the law that would prohibit that. So this bill does many things, but right off the top, it says that these products are only going to be sold to those that are over 21 years of age. It will put an appropriate tax on it. It is a mild registration fee for those that want to be licensed to sell this product. It will have packaging requirements, and those packages will include significant labeling so that folks know exactly what this is. It will require private testing from labs. We've heard testimony from labs that can do that. It doesn't have to be a state lab. In fact, the preference would be if the private market out there can do this, then why would we have a state lab that has to do this? They will have to hit very high standards, however. And in fact, most of these packages have QR codes where folks can actually scan that and get very detailed information on exactly what they are buying. It will have caps in the amount of THC that can be in these products. And it specifies very clearly that what we are regulating here, and heavily regulating as we should, are those THC elements that are psychoactive, that can potentially have an effect on someone's central nervous system, that can create a high, quite frankly, and might not in some products and might in others. And there are a vast number of products that are out there, and we're specifically trying to stay away from those products that have none of those psychoactive elements in it. And you can see on page 2 of the amendment that is laid out. And that's what you've heard in the past, and this is an oversimplification, but kind of CBD versus THC. Now, nothing in this bill legalizes marijuana. It is clearly defined in our statute as 0.3 Delta-9 THC or above. That is absolutely still illegal. I know that there are advocates on both sides of that, but this bill doesn't go there. What we're dealing with are products derived from hemp that are on the market right now. The original fiscal note said that if we reduce this down to 0.3% THC, total THC, that many of those products would not be available any longer, and the fiscal note was about $3 million a year of the basic sales tax. The fiscal note on this bill, with a 5% tax is all we're talking about on this, which is under what alcohol and tobacco are currently taxed on. It's slightly more than what other products are, but a 5% tax at the retail level brings in approximately $10 million per year. So we're not doing that for this, but it does show that there is obviously a market for these products already out there that is growing. So this allows that market to continue, but it puts severe restrictions and much necessary restrictions on this industry. And quite frankly, the best actors within this industry have been in my office and all of yours to ask for those very restrictions and regulation. They want to be selling products that folks can safely take and know the risk. And so if they know how much of a product is in each one of these products, how much THC is in there, exactly where it came from, exactly what potency, then it is the example I gave before. If someone drinks a beer and they choose to do that, then they know roughly the alcohol content that's going to be in a beer. They know, I'm sure, many folks that drink beer from personal experience, what happens if you drink 12 of them. But what they don't have to worry about is getting a can of beer and it being a can of pure grain alcohol. I mean, it's just not going to happen in the regulated society that we have out there. And that is what the attempt on this is, so that if someone is purchasing one of these products, it is definitely more at the lower end of the spectrum, and there is nothing that would keep someone from potentially taking multiple of these items. But it will not be marketed to children, it will not be sold to children, and quite frankly, it will not even be in a form that isn't like a cartoon character like a teddy bear, so that a child could even mistake it for something else. So that's the goal of this bill, and I stand ready for questions.
Members, you've heard the explanation. First on my list, I have Chairman Dixie recognized.
I have a quick question. It's for the sponsor. The subsection 4327 to 11, section 4327 to 11, section B. Can you explain to me what the difference is between a mythical character and a unicorn?
Leader Lamberth, you recognize.
Yes, which subsection are you going from?
It's page 8, the very last paragraph on page 8.
Mm-hmm. So it specifies there specific. It just lays this out, and this is stuff that is taken from what we utilize usually for tobacco products and others that's been litigated out for years. And it specifically says not limited to superheroes, comic book characters, video game characters, television show characters, movie characters, mythical creatures, and unicorns. There are apparently some products that have been on the market in years past. If someone is selling a product like this and it is in the shape of a unicorn or a movie character or a mythical creature, it's pretty clearly marketed to kids. Most of us as adults could care less really what the shape of the item is that we are purchasing. It's not going to attract our attention that much. Most of the folks that are purchasing these products, quite frankly, are purchasing them because of the contents of them. If it is shaped like a unicorn, it is designed, and I will be very clear about this, in most cases, though it can be a young boy or a young girl, they are marketing probably to a young girl under the age of 10. To me, that is something that these products should not be. Those are individuals that should not be marketed to in these products, and I think most in the industry agree.
Chairman Dixie, you recognize.
Thank you for that detailed answer, which I was not expecting. But I just was thinking that a unicorn, a unicorn was a mythical character. But I think this is a great deal. I think that we did need some regulations about who can buy these, the dosages, packaging. I think this bill is right on point. So I'm glad it evolved from what it was to what it is now. And so thank you for making this amendment, because I think it's very much needed, and thank you for helping this industry to help people who actually need it for good purposes.
Thank you, Chairman Dixie. Leader Lamberth, you recognize.
Thank you, Chairman. I appreciate your support of the bill. I will say that there was a lot of conversation. There are also some warning labels that will be on the packaging, like keep out of reach of children, like the fact that many of these products do impair someone's ability to be able to operate a motor vehicle or heavy machinery. Folks should use caution when utilizing these substances, these products, but it's their choice as to whether or not to do so. There's also some language in here, and I will say this publicly. I have great concern at some of the medical claims that have been made by some of the vendors. Some of those claims have absolutely no medical basis whatsoever. Others do. And so I will just say, and this is really to anyone that's in the industry that happens to be listening today, I think if this bill is successful and this industry continues to thrive in Tennessee, we will all be watching very closely. And in this bill, it's actually regulated under the Department of Ag. I've spoken with them. They are very capable of doing that, according to what they've shared with me. And I will say, as an attorney, I would be very, very careful making a medical claim where you're telling someone this is going to do this. If there's medical basis for that, great. If there's not, a vendor is putting themselves in a very tenuous legal position if a customer relies upon that medical advice. So I would just be very careful about that. We didn't go deeply into that in the bill, but it is something that continues to be a concern of mine where, folks can make their own decisions, but the best medical advice is from a licensed professional, specifically a doctor. So,
thank you, Leader Lamberth, and I will say too, looking at that section, at my household we have a 9-year-old daughter, and she absolutely believes in unicorns. So I was glad to see a comma between mythical creatures and unicorns. No, sorry, no, sorry. That's right. No, all kidding aside, Leader. I know you've worked very, very hard on this bill, and I think we've got some members with some other questions, but. To me, this is truly, what leadership looks like, is that you identified a problem in Tennessee. It is a massive problem if one of my children, none of whom are of age, can walk into a gas station and walk out with something that, can absolutely not be good for them, and especially if it's marketed to them as a child. Right now, we have no regulations. And this is a way to rein this in. So you've seen a problem, you've tackled it. I know this is not your or my favorite issue, but it is one that I know that you are working on, and that means that we're going to get it right. And if we don't get it right, you'll come back next year and you'll continue to work on it to continue to get it right. So thank you for your leadership on this. Next on my list, I have Representative Hardaway. You're recognized.
Thank you, Chairman. I'm glad you straightened out Chairman Dixie about the unicorns. Found that quite offensive, Chairman Dixie. To Leader Lambert, you answered some of my questions looking for specifics of what would be on the label. You just cited the issue of false medical claims. Is there something on the label that's compelled by your legislation where those claims can't be made? And if so, would those be civil or criminal violations?
Leader Lamberth, you recognize.
Says there must be excuse me, this is page 8 of the amendment. It's under subsection 4327-211, subsection part A 2C. It says a statement that the product is not approved for any medical use by the United States Food and Drug Administration will be on each one of the labels. I do feel like that's important. And again, ag will be regulating this, but it would potentially be an administrative finding. You could, I would say, potentially would lose your license to be able to sell these products if you were not abiding by that labeling requirement. And if someone is making, just like right now, there's a consumer protection division of the Tennessee Attorney General's office. And if someone is taking advantage of consumers on a regulated product in this state specifically, then the Attorney General's office can take care of that. And they do a very good job of that.
Representative Hardaway, does that answer the question?
Yes, sir. Would ask that the leader go further. Are there other disclaimers on other products similar to this disclaimer? And if so, are the consequences, legal consequences, the same?
Leader Lamberth?
Yes, sir.
Representative Hardaway.
Thank you. The 5% tax, is that earmarked for any particular uses by the state, such as education or substance abuse or things of that nature?
Leader Lamberth.
Yes, sir. Primarily that, and that is under subsection, the tax, and I'm just going off memory here, I was flipping over to the subsection real quick.
Top of page 5.
Top of page 5, excuse me, I was on page 4. So it is specifically going to go to a special account of the State General Fund and allocated to the Department of Agriculture to be used exclusively for the regulation of products containing a hemp-derived cannabinoid in this state. So to begin with, it would go to the Department of Agriculture to spin up a kind of a division within a division that already does regulation now on food products and other items, but they would be specifically designated to do this job. And any excess from that obviously would go back to the general fund in future years, any surplus from that. But initially, this is going to be utilized to set up what I hope will be a very robust regulatory entity that will work well with the industry and be very easy to get a hold of, and quite frankly, be very swift to come down on anyone who violates this section.
Representative Hardaway, you recognized.
Thank you. Leader Lambert, and you may agree with me that one way to ensure that the regulatory process is successful is the education of the consumer. So can we assume that the Department of Ag is free to use the educational tools that it deems necessary to aid in the regulatory process?
Leader Lamberth, you recognize.
Yes, sir. I think that would be a very reasonable assumption from the language of this bill, and quite frankly is good advice to the Department of Ag to reach out to not only just vendors, but customers as well, to ensure that that regulatory structure everybody understands well. So yes, sir, I think educational, both materials and individuals out there educating folks on this, it's a very good idea.
Representative Hardaway, you wish to be recognized again?
Yes, sir. Just to thank the leader for the thoughtful way that he interacted and worked with the industry personnel. They seem to be happy with it. And to thank him for a timely bill that saves our children from making big mistakes, and some adults.
Thank you, Representative Hardaway. Next on my list, I have Chairman Hawk. You're recognized.
Thank you, Mr. Chairman. Echo the comments. Thank you, Leader Lamberth, for the diligent work that you've done over this whole session, and especially the last 2 weeks in crafting this amendment. So thank you very much. I know you've heard our concerns loudly and clear. I appreciate that. And forgive me, I normally will ask you a question before I ask you a question on the microphone. So I do want to know, we've got staggered implementation dates. Some of the bill will go into effect upon signature of the governor. Some will go into effect on July 1 of this year. Some will go into effect on January 1 of 23. Can we talk about just the rationale behind the staggered implementation? And I'm sure some of that is allowing the Department of Agriculture to get the process and the program up and running, but certain segments will go into effect at certain dates.
Leader Lamberth, you recognized.
Thank you, and as soon to be the dean of our caucus and longest serving Republican member, that's the kind of question that I appreciate, because I was looking at that just beforehand, and you probably knew that I was. So part 202, 203, and 204. So basically pages 2, 3, and 4 of the amendment would take effect July 1st, and part of that is to promulgate rules to spin up this, new regulatory entity underneath ag. And again, they already have a regulatory entity, but kind of a subset of that would just handle this. So it has the definitions in there. It has what they're to work with. It allows them to have those definitions. It also says that starting July 1st, no one, even if they're not yet licensed, because that goes into effect January 1st, but starting July 1st, no one's allowed to sell to a child. So if you're under 21, in fact, 18 to 21 is an adult, but we drew the line at 21. Starting July 1st, no one's allowed to sell to a child, and it would be a misdemeanor to do so. And so I thought that was important to go ahead and get in the law, and that's really what 202 and 203 focus on, is that you cannot do that starting as soon as possible.
Chairman Hawk? Okay, thank you. Next on my list, I have Representative Griffey. You recognize.
Thank you, Mr. Chairman. I think Chairman Hawk answered most of my questions. Michael, I did have concerns about how soon people under 21 would be prohibited from buying. The other question, some vendors may have purchased product before this change in the law, and some of them could get kind of hung up on that. How will the effective dates address that situation, if you could, please, Mr. Leader? Thank you for your leadership on this bill, too. Thank you.
Leader Lamberth, you recognize.
So January 1st is when most of that would go into effect in 2023, largely for that reason. Again, it is a completely unregulated industry right now. All of us here, I think Republican and Democrat, try to keep the regulatory burden on Tennessee businesses as low as possible. But to ensure the safety of Tennesseans, there's always at least a bare minimum of regulation. Since there's been no regulations to this point, over the last couple of years, this industry spun up pretty quickly. We're giving them a bit of grace period, though I will say publicly, and I think many of them would agree with this, the folks that are actually already in the retail sale of this, that these are best practices. So the sooner someone can come into compliance with this, the easier it's going to be on everybody. And the 115 overdoses I mentioned last week, or week before last in sub, 30% of those are under 5. So that's not someone who's intentionally taking one of these products and taking too much. Quite frankly, even the adults that wound up in the hospital or suffering from, a medical emergency there, it's unlikely, at least from the conversations I've had from folks in the industry, that those folks intentionally took too much of this product as well. This is much milder than what we've commonly known as marijuana. Most of these products are milder than that, and it has caps in here on that. And so some of those likely were from where someone got a product that had much more THC in it than they would have anticipated. So hopefully, as soon as we possibly can, that will get under control. But because of the fact those products are already out there, January 1st, 2023.
Okay. Next on my list, I have Chairman Howell. You recognize.
Thank you, Mr. Chairman. And for the sponsor, you and I have had many, many long conversations about this issue. And I think I know your heart, and I believe that, as we've discussed, the genie's out of the bottle, and you're attempting, in good faith, I believe, to put some parameters around it. But for the benefit of those who are watching by live stream, just for clarity, and I think I know the answer to this already, but many people have approached me about this in my district. This bill just addresses the side products like CBD oil, gummies, things like that. If this bill passes, someone over the age of 21, they will not be able to go into a convenience store, a CBD oil store, and buy a baggie of weed and roll a joint and smoke marijuana. Can you address that?
Leader Lamberth, you recognized.
Yeah, that type of behavior would absolutely still be prohibited. Again, marijuana is an illegal drug in Tennessee. It is defined very clearly as anything that is 0.3% Delta 9 THC or higher. I will say, and we talked about this some in the subcommittee, and I've had lengthy conversations, both with you, Chairman, and with others, there is still an argument that some of these products would be illegal under the analog statute at the state, at the state level and the federal level. The problem with that really comes down to, and this took several weeks and lots of conversations, even for me, to come around to, it's very difficult to prove that. So trying to prove exactly where an end product came from and say, well, it came from marijuana, or, well, no, it came from hemp, once it's distilled down and out in another product, a gummy bear, something else, it's very, very difficult to nigh impossible to prove that it came from marijuana versus came from hemp. And so when we drew that distinction in the statute several years ago, we kind of created this issue where we've left, again, vendors and consumers in a gray area. But one thing that is crystal clear is that this bill does not legalize marijuana. I have said publicly that I do not think that we should go down that road. What it does is it regulates products that, by the original fiscal note, you saw that if we even dropped the percentage down to 0.3% total THC, it would have been about a $3 million sales tax reduction to the state of Tennessee. These products are being sold currently. They are paying sales tax. And so, multiply that times roughly 10, and you can see, and you can look in the fiscal note, kind of what the size of the market is out there for THC products that are not marijuana. And so that's what this regulates, and it regulates those that are specifically those that have psychoactive compounds. So again, not marijuana, but the only distinction between hemp and marijuana, it's all the cannabis plant, is the legal distinction that we have drawn, and that is a distinction that remains in this bill.
Thank you for clarifying that, Mr. Chairman. I just felt it was important for those who may be watching to get that clarification. Thank you.
Thank you, Chairman Howell. Members, that exhausts my list. Without any others on the list, we're ready to vote. All those in favor of sending House Bill 1927 as amended to GovOps, please signify by saying aye. Aye. Those opposed? Sir, the ayes have it. You head to GovOps. Members, that brings us to the heel of today's calendar. Item number 9, House Bill 2524 by Vice Chairman Sexton. Vice Chairman, you're recognized.
Thank you, Chairman Curcio. And as you and I have discussed this, we know the situation of it in the Senate, and I don't want to be a burden on the committee, but I would ask a favor that if it be your will and the will of this committee, I'd like to put these amendments that I have. I've got two. I can put them both on, or one or the other. What's your pleasure, Mr. Chairman?
Thank you, Vice Chairman Sexton. Members, the situation we find ourselves in is House Bill 2524 has been sent to summer study in the Senate. The Vice Chairman has requested that we at least put his amendments on the bill so that for the official record in the system, this bill will be in the posture that he intended for it to be in. And after that, I believe it would be your intention to take the bill off notice. So we have a motion on the bill. Do I hear a second? Second. And Leader Lamberth, you wish to be recognized?
Yes, sir, Mr. Chairman. I had filed an amendment that I had spoken to both the sponsor of the bill and some others. It is on the marked calendar. I believe it was timely filed. I will be withdrawing that amendment. If we're going to allow the sponsor to go forward with the amendment that I believe was untimely filed, if there's a chance of that, then my amendment would not be needed. It was an attempt for me to try to get something out there that would resolve some of these issues. But again, if the sponsor has an amendment that he would prefer to go with, then I will withdraw my amendment.
All right. Without objection, amendment withdrawn. Vice Chairman Sexton, you're recognized.
Yes, I do have an untimely filed amendment, and I guess you'd like to have that number, wouldn't you?
I believe it's coded 17130. Is that what you have?
That sound, yes, 17130.
We have a motion to consider. Do I hear a second? All right. All those in favor of considering this amendment, please signify by saying aye. Those opposed? And now we need a motion and a second on the amendment. Motion. Sir, you have a motion and a second. You're recognized.
Thank you. And let me just mention this. When we had this in the subcommittee, there was a lot of questions by this committee. And I made a promise to the committee, both in special meeting and in our committee meetings, that I would address each and every one of those questions that was brought before me in the committee. And so we watched the video, my assistant and I, and Michelle actually worked with us on that and I think she can verify that we were very did I get your name right? Okay. That we were diligent in trying our best to comply with the promise that I made to the committee that I would address those. That's what I tried to do with this committee. We actually did that, and then there was kind of a typo or a little problem that needed to be corrected, and so we had to go back and fix that. But that is what brings us to the point that we're at now, and I would like to get this amendment put on it, and then we'll take it off notice.
All those in favor of adopting amendment coded 17130 to House Bill 2524, please signify by saying aye. Those opposed, you adopt. Vice Chairman Sexton, thank you very much for your work on this. You're recognized.
Thank you, Chairman. And if by chance that the Senate was to reconsider their actions, is there a way for us to put this back?
I believe the motion you're about to make is take the bill off notice, and after today's meeting, will be closed subject to the call of the chair.
Okay. That's good.
Okay. Members, without objection, House Bill 2524 off notice.
Thank you.
Members, that brings us to the end of our business today. I want to thank all of you for the work that you've done in this committee. This is one of the hardest working committees in the House. We ask you to read a lot, we ask you to weigh in, and we have some fairly long and sometimes contentious meetings, but you always show up and you do your work, and I can't thank you enough, and it's been my distinct honor to get to serve this committee. Representative Hardaway, you're recognized.
Thank you, Chairman. A point of personal privilege, please. I have a guest. I'm going to ask her to stand. Melissa Lawrence. Melissa is a public policy director for Sister Reach, which is an advocacy group for women and families with a strong focus on equity and equality in education, economics, housing and health, public policy issues. So I want y'all to recognize her and thank her for her work.
Next on my list, I have Chairman Dixie. You're recognized.
Thank you, Mr. Chairman. I just want to tell you, Mr. Chairman Curcio, thank you for your leadership in these committees. I've only served on this committee for 2 years, but I appreciate you, even when I had bills before I was in this committee, of actually working through it, sitting down, talking with me, really taking this committee to heart and wanting the best bills to come out in the best posture. So you will definitely be missed as chairman of this committee, and I really appreciate your steady hand and your heavy hand when you hit the gavel also, but your steady hand in leading us throughout this committee. So thank you so much, and I appreciate getting to know you, even though it was a short term here for me and you, but thank you so much, and I learned a lot from you during this time.
Thank you, Chairman Dixie. Thank you. Thank you. Brings me to Chairman Hawk. You recognize, sir.
Chairman Curcio and Vice Chairman Sexton, I cannot begin to thank you enough for the diligent work that you have done leading this committee over the years. Much like other folks on this committee, this has been out of my comfort zone, to be very frank. I have not worked in this world or in this line of work, but what I have learned and what I have seen through your leadership has been tremendous. And the way you have guided this committee, the ability to allow all sides to have a say, to have input on bills as we've gone through this has been admirable. And I want to say thank you for the work that you've done, Chairman Curcio, Chairman Sexton, the work that you've done. You're no longer a poser anymore, Vice Chairman Sexton. But this has been a tremendous learning experience for me and for all of us, and we all take a little piece of this committee with us as we go forward, and you have been great in sharing yourselves with us. So thank you very much, Chairman and Vice Chairman.
Thank you, Chairman Hawk. I appreciate those kind words. Next on my list, I have Vice Chairman Sexton. You're recognized.
Thank you, Chairman Kersey. I just want you to know that it's been a pleasure to serve as your vice chair. You've always been very gracious to me in anything that I've asked, and it's been a pleasure to serve under you. You run a very firm, but fair sometimes, committee. And I do appreciate the opportunity to get to serve with you. And, of course, I won't be here next year either, but We'll miss.
We'll have to tune in together and watch these guys work next year.
Yeah, and we'll oppose everything they do,
That's right. That's
Opposers,
right. It will be-
opposers, twins.
That's right.
I also want to say that Michelle does a great job. I've worked with her on some bills, and she just very gracious. They worked over the weekend, and these two guys right here, you know, they don't get much credit, but they sure make us look good sometimes. Right. It's hard to make me look good, but they make Chairman Curcio look real good.
Yeah.
But they really do. They keep us in line, and they are just the best. And I've worked with some. I just want you to know I appreciate you very much, the work that you do. Thank you.
Thank you, Vice Chairman Sexton. The feelings mutual. Appreciate getting to work with you. Next on my list, I have Leader Lamberth. You recognized?
Mr. Chairman, you're doing a fine job. So I don't know how many times I've probably told you that, but and it's because I've sat where you are. I've been there. Many of us in this room have chaired a committee or are currently chairing a committee, and it's a very difficult job to be the one person that no matter what bill is in your committee, even if it's not on notice, even if nobody's ever read it besides maybe the sponsor and one other person that's asking you about it, but they come to you and say, "What's going on with this bill?" And I can proudly say there's rarely been a time that you didn't immediately know or immediately found out because you study hard at this stuff. And what a lot of folks don't know, who only know you as Chairman Curcio, is that when I was chairing this committee and you were a mere freshman and came in as my vice chairman, just as Jerry was, I remember some of those early conversations, and it was like, hey, this isn't really my area. This is not something that I know well. I'm not an attorney. I'm not a district attorney or a law enforcement officer. And I can proudly say, just as I've said to many other people, and you and I had those early conversations, look, this is hard work, but anybody can do it. If you just care about people and you want to make sure that justice is done and Tennessee is kept safer or is safer after we get done each year than it was when we started. And I can say that you far exceeded any of our expectations in diving into this area of the law and made yourself an expert in it. And that's all any of us should do down here, is to listen to folks and learn from folks that are coming to us. And you went above and beyond that and then became the chairman of the committee, in large part because you'd become that expert. And it doesn't mean that you knew the answer to every question. Just as others have said, it means that you were willing to listen and learn from everybody, both those that in favor of what you were doing or were opposers to what you were doing. And it's been a real pleasure to be your friend. And I genuinely appreciate the time that you've served in the legislature and what you've given to the state of Tennessee. I wish you well in your future endeavors, and I know that we will all miss both you and Jerry and others that are not running. But none of us are designed to be down here forever. But in the time you've been here, I can proudly say that I am confident in the fact that you have left a mark on the laws that are written in those green books over there, and the leadership that you've shown on this committee has definitely made Tennessee a safer place and a more just place. And both of those are important. So thank you, Mr. Chairman.
Thank you, Leader. Thank you very much. Next, I have Chairman Holsey. You recognize?
Thank you, Mr. Chairman. In light of Representative Dixie's questioning to Leader Lambert on the verbiage on the bill, I was just going to give you some advice that Jerry Sexton gave. He said, don't ever play leapfrog with a unicorn. So there you have it.
Okay. Duly noted, Chairman Holsey. Chairman Howell, you recognize?
Thank you, Mr. Chairman. I want to add my voice to the chorus of commendation for the job you have done. You've done an outstanding job. It's been a privilege of mine to serve on this committee, and we've done some heavy lifting. I'm not sure that our constituents realize how much heavy lifting is done in this committee, and you've been a great leader at that, and I appreciate that. And I also want to say I appreciate Vice Chairman Sexton. We came in together, and thanks to him, I have added a new word to my vocabulary, opposers.
Thank you, Chairman Howell. It's been an honor to serve with you. Chairman Doggett, you recognize.
Thank you, Mr. Chairman, and I will exercise this opportunity here to follow along with some of the same comments that my colleagues have made. But I want to both of you, I want to say what a joy it has been to serve with you for both of you, for your leadership and your guidance, the work in your service to your districts and the people of this great state. We have an enormous, it is really, it's a blessing to be able to serve in these capacities in which we do. We set the policy for the state. We write the laws in which each and every person that lives in this state and travels through this state or deals or has interactions with the state, we're the ones that do that. And it's an enormous responsibility, and it's one that we don't take lightly. It's one that when a bill comes, especially through the criminal justice committee, you can, if you don't do things right in criminal justice, you can really mess up the law real easy. And I'm proud of the work that we've done in the 4 years that I've had the privilege to serve in the Criminal Justice Committee. But I feel I'm very confident in what we've done is very good work. And that goes back to you two for your service that you've done on this committee and for your efforts. And so, again, I want to say thank you. I'm very grateful for your friendship, and we're going to miss you going forward. But best wishes to your future endeavors.
Thank you very much. Members, I just want to say it's been my honor. I've really enjoyed chairing this committee. It has been it's been a task at times, but it's always been one that I've enjoyed. I want to thank Michelle Fogarty. She is always quick with an answer when we play Stump the Lawyer, which is our favorite game. I also want to thank the clerks that have worked hard on this committee, and of course, I want to thank John and Heather, who have worked very, very hard to keep me in line and to make sure that I don't say anything too drastically idiotic. So thank you very much for that. And of course, Vice Chairman Sexton, thank you. I've appreciated your friendship. I'll never forget coming to your office as a wet behind the ears freshman with a bill that you absolutely hated. But when I walked out, I knew that we were still friends, and I appreciate that. You've always been very kind to me, and it's been a pleasure serving with you. So with no other business before the committee, we are adjourned subject to call of the chair. We are closed subject to the call of the chair.